Well, good morning, America. This is Stuart Ryan with another edition of the Ryan Report, and with breaking news as of this morning or late last night, as reported by Politico, definitely this morning. Appeals court blocks Newsom's bid to reclaim control of the National Guard from the fascist king, Donald Trump. This is a freaking disaster for democracy in America. But let's look at the order and opinion. Before we do that, let's go to the reporting from Politico. A federal appeals court has indefinitely blocked an effort by California Governor Gavin Newsom to reclaim control of the National Guard troops President Donald Trump deployed to Los Angeles following quote unquote unrest related to immigration enforcement. An invention. The three-judge panel of San Francisco-based Ninth Circuit Court of Appeals ruled unanimously that Trump appeared to have acted within his authority when he took control of 4,000 California National Guard troops under a law that has never been invoked without the consent of a state governor. And this is 10 U.S. 12406, which I have discussed before. Further, despite a debate over the level of violence accompanying the protests, the judges, two appointed by Trump and one by President Joe Biden, concluded that the law gives Trump enormous latitude to determine that the protests and related violence, who says the violence is related? Where is the objective truth in that? We're interfering with the execution of federal law. How? All of these arrests and detentions were carried out, and whatever problems evolved at night and were handled by state and local police without further incident. But never mind. The judges said there are limits to the president's ability to call up the guard, but there was enough evidence of civil unrest and danger to federal officials to justify Trump's actions. Are you fucking kidding me? There wasn't enough civil unrest or danger to federal officials to trouble anybody. Everything was being handled by civilian authority and with no problems whatsoever. When you consider the numbers of protests in their thousands, multi-thousands, and the few incidents at night of scofflaws and idiots going out and doing stupid things, which were handled. So this is complete freaking nonsense of a description of the order and opinion. Now let's go over the per curiam opinion. This was heard by judges Bennett, Miller, and Jennifer Sung, who is better known, as I watched the hearing on Zoom, as the silent one. What a fucking idiot she is. But never mind. Let's go back to 10 U.S.C. Section 12406, which again I have discussed in other videos, and I gave a breakdown of the three elements that have to be, one of the three at least, satisfied in order to justify the federalizing of federal troops. Back to the per curiam. In 10 U.S.C. 12406, Congress authorized the President of the United States to call into federal service members and units of the National Guard of any state whenever one or more of the three conditions are satisfied. In response to disturbances in Los Angeles stemming from federal enforcement of immigration laws, the president invoked Section 12406 and only that statute he didn't authorize this action under the Insurrection Act. That's what they're saying. And he ordered 4,000 members of the National Guard into federal service for 60 days to protect federal personnel performing federal functions and to protect federal property. The state of California and its governor, Gavin Newsom, sued the president, the Secretary of Defense, and the Department of Defense in federal court. Rightly so. Plaintiffs alleged that the defendants' actions were ultra-virus and violated the 10th Amendment to the United States Constitution. They also alleged that the Secretary of Defense and the Department of Defense violated the Administrative Procedure Act, APA. The plaintiffs applied for a temporary restraining order, a TRO, and after a hearing, Judge Breyer in the district court issued the TRO enjoining defendants from deploying members of the California National Guard in Los Angeles and directing defendants to return control of the National Guard to Governor Newsom. And that opinion, which I have read, was clear and convincing, beautifully written, and now completely disregarded by these three fascist fools sitting on the Court of Appeals as an appeals panel. Now, returning once more to this opinion, we now grant the stay. In other words, the injunction is, the TRO is lifted. Defendants have made the required strong showing. I can't believe that they're likely to succeed on the merits of their appeal. If that's the case, we're in fucking trouble. We disagree with defendants' primary argument that the president's decision to federalize members of the California National Guard under 10 U.S.C. 12406 is completely insulated from judicial review. So at least they're protecting their own home turf because they don't want the judiciary to be left out in the cold and powerless. So they're saying that though they're granting this stay, they're not going to accept the arguments that the courts are not allowed to review what the president has done in his discretionary authority to employ this or other statutes. No, so they're saying it is not a political question. It is justiciable under the laws of the United States and the United States Constitution. However, while it may be justiciable, which is a saving grace for this order, thank God for that little favor, they go on to say, nonetheless, we are persuaded that under the long-standing precedent interpreting the statutory predecessor to Section 12406, our review of that decision, and I don't know which act that is, there was an act in 1903, I believe. However, the decision must be highly deferential. And frankly, this is nonsensical. Affording the president that deference, we conclude that it is likely that the president lawfully executed and exercised his statutory authority under Section 12406, which authorizes federalization of the National Guard when the president is unable within the regular forces to execute the laws of the United States. Unquote. Now, this is a complete nonsense because there's no factual evidence developed in the court below to which deference must be paid to Judge Breyer, who had access to the facts and created the record. There's no business here of this three-judge panel of setting aside or refusing to accept his factual analysis, which led, along with the law, to his decision to allow for a TRO. But worse than that, it presents another problem. Statutes like 12406, however powerful in their three-pronged approach, which is mirrored in other statutes, fail to rise to the level of the Insurrection Act. And this is significant because, why? Because the Insurrection Act is the only act which supersedes Posse Comitatis, the Posse Comitatis Act, which declares that the military shall not be in the streets of our country, taking the place of state and local resources, to be avoided at all costs. Every statute that deals with an allowance for the president to exercise some discretion, the only statute which supersedes 1206, Section 3, is the Insurrection Act, which supersedes Posse Comitatis, as I've explained in other videos. Now, even accepting this notion, which is not law, of giving deference to the executive, to the president, even if you accepted that deference, that does not dismiss the fact that he cannot invent a crisis orchestrated by sending in these ICE, Gestapo enforcers. And then when protesters go into the streets, he's not declaring an emergency, but he is declaring an emergency which would allow him to say that the laws can't be faithfully executed by him because it's out of hand, the situation and circumstances. And there is no proof whatsoever that state and local law enforcement could not and did not handle those few midnight to 8 in the morning inconsequential offenses against the law. They initiated a curfew that sorted that problem out. In no way, at no time, did these federal troops purportedly defending federal buildings, which isn't all that they did. They threw fear into the hearts of the citizenry. At no time were they stressed. At no time did any mob charge at them. So this whole idea of deference is A, dangerous, and B, becomes ridiculous when there are no facts whatsoever to conclude that the president is acting in good faith. Finally, I hope, they also made a finding in this scurrilous and absolutely horrible order and misalignment of legal theory and gobbledygook into a victory for the Gestapo and for the fascist president. They also made another conclusion, and I quote, "We also conclude that the other stay factors, irreparable harm to defendants, injury to plaintiffs, and the public interest, all of the factors involved in making that particular decision, weigh in defendants' favor. Thus, we grant the motion for a stay pending appeal." How insane is that? How out of touch with fucking reality is that? It's nonsensical. What irreparable harm does it do the United States government to withdraw those federal troops and allow local agents to deal with the law in LA, where the videotape shows the protests had been peaceful and the complaints about an occasional problem are absolutely minor. So to throw it back onto the California and to government there, that there's no irreparable harm to them when the threat of military in the streets in and of itself is irreparable harm. As Posse Comitatis points out, and that's what the law should be, unless they're going to call into effect the Insurrection Act, and then we have a different kind of battle. So what are we left with? What are the options on the table here as the case in the lower court goes on? Because the preliminary injunction hearing is not canceled, but the time is of the essence here. We cannot allow this kind of decision to stand and become a small precedent for allowing presidential misbehavior to go unpunished and unresolved. Otherwise, we're living in a dictatorship because any president can be a tyrant, and deference to his discretionary powers when they're being misemployed is a complete legal, counterintuitive, unconstitutional fucking nonsense. So, Governor Newsom has two options. One, go on with the efforts to get a preliminary injunction. The other is to ask immediately for an en banc hearing by the full 11-judge panel of the Ninth Circuit, in which this might be turned around. Barring that, which takes time, he can, and the state of California can, apply for emergency relief to that infamous fucking Supreme Court. And what they will decide, well, we have an inkling of it from this case. They put him where he is. They gave him the ability to break the law. And can we depend on them to do the right thing here and follow the law and follow the Constitution in defense of those rights and foundational principles to which we are all entitled and should not lose after almost 250 years? Thank you.